let's take a look at what makes an accommodation reasonable. Under the ADA, employers are required to make reasonable accommodation unless doing so would impose an undue hardship. Most often, the interactive process results in a mutually acceptable solution. In cases where an employer's ability to provide a reasonable accommodation is disputed, the exact meaning of the terms reasonable and undue hardship become important. The ADA does not define reasonable accommodation beyond providing examples. Case law and EEOC guidance suggest a number of criteria for the reasonableness of a proposed accommodation. Employers remain free to exceed minimum legal requirements in meeting the needs of employees. The following are criteria for determining the reasonableness of a proposed accommodation. It's effective, it doesn't need to be the employee's preferred option, it doesn't include provision of items for personal use, and it doesn't need to match previous accommodation. Further, working conditions do not need to equal those of other employees. It doesn't require creating a new position. It doesn't require providing paid leave not available to other employees. It does not require eliminating essential functions or lowering standards, does not require excusing misconduct, and does not usually require making exceptions to seniority rules. Employers are under no obligation to create new positions for, promote, or displace, like bump other employees to accommodate disabled employees. However, reassignment to a vacant position can be a reasonable accommodation and must be considered in situations where a disabled employee cannot be accommodated in her present job. Reassignment is Plan B if it proves not to be possible to provide accommodations that will enable employees to perform the essential functions of their current job. There is some ambiguity surrounding the meaning of vacant, but at least one court has held that it would be available for a similarly situated, non-disabled employee to apply for and obtain. Courts have differed in their views of how far employers must go when using reassignment as an accommodation. The EEOC believes that the ADA requires reassignment and not merely consideration in such situations, and some appeals courts have agreed. Other appeals courts, however, have ruled to the contrary. Another significant form of reasonable accommodation is job restructuring. While employers need not eliminate essential functions from jobs to accommodate disabled employees, non-essential functions must be eliminated. Employers are not required to reasonably accommodate disabled employees by permitting substandard performance and misconduct, even if these performance problems are the results of an employee's disabilities. Ideally, such incidents would prompt the interactive process to determine whether accommodation is in order prior to disciplinary action being taken. Employers must sometimes reasonably accommodate disabled persons by providing periods of leave under circumstances different from or in durations longer than the leave normally available to non-disabled employees. But the question of how far employers must go in modifying their leave and attendance policies to accommodate the needs of disabled employees is a matter of considerable debate. Employers are not required to provide paid leave to disabled employees that is not available to all employees. But how much leave must be given before it's concluded that a leave is no longer a reasonable accommodation? How many times must leave be provided anew or extended? There's no simple answers to these questions, but the main message to employers is to be flexible. An employer does not have to wait indefinitely for the return of a disabled employee from leave, so the failure of an employee to provide even an estimate of when she could be back at work was fatal to an ADA claim. Leave whose duration extends beyond the maximum leave period provided for under the FMLA or the Family Medical Leave Act might not be required as a reasonable accommodation. At least for the EEOC, the key issue is whether there's any reasonable prospect of the disabled employee being able to return to work.